Before we begin our first panel, I wanted to thank Michael Waterstone, the Dean of Loyola Law School, for supporting our clinics that train law students to holistically represent crossover youth in delinquency court and in educational proceedings. And I also want to thank the Everychild Foundation, and specifically its founder, Jackie Castro, for providing generous funding to make it possible for CGLP students to represent so many crossover youth over the past 3 years. We really appreciate it. So I'm going to turn it over to our Dean to start with some remarks. Michael, you have the floor.
Thank you, Sean. Welcome, everybody. It is great to be gathered even virtually like this. Just a few thank yous. I want to thank Sean Kennedy for his leadership, his passion. In so many ways, Sean represents the best of who we are and who we hope to be. So Sean, thank you for all of your efforts to make today possible. I want to thank our conferences and events team. Lindsay and her group just do an amazing job and provide platforms, both real and virtual, for us to convene and have these conversations. So thank you all for what you put together. We really have the most incredible team in the business. Today is an important day. It's a moment. I think it's no mystery to anyone joining us today that in many ways we have a broken access to justice system. And too often the people that are on the losing end of that equation are the most vulnerable, our children, people of color, disadvantaged communities. And we view our role at Loyola as being a solution on that, on working to change, to create a more just world. And we do that both through the work of our clinics directly helping to fill that access to justice gap, but we also do it through training a next generation of advocates and teaching people how to do things the right way. And that's what makes a day like today such an exciting day. I want to thank the Everychild Foundation for their support of the work on crossover youth done by the Center for Juvenile Law and Policy. And certainly the services that we provide to the community, which we care deeply about, rely on grant funding and donations. So to the Everychild Foundation, we are so grateful for your philanthropy. You fuel our success and the vision of what we're able to accomplish in the future toward pursuing a more just world. So thank you. As Sean mentioned, in this project, we provided holistic education and juvenile justice advocacy and social work for crossover youth. Those are youth involved in both the foster and juvenile criminal systems. Now, we started this before we entered a global pandemic, and let me assure you that the work has become even more important during the multiple crises caused by the pandemic, which amongst other things brought into stark view the difference in services and resources available to these youth. And these times have made even clearer how important it is that we continue our representation of these individual youth and our system change advocacy to address the issues faced by our clients. So thank you. We are grateful to be of service. And now I want to turn things over to the president and founder of the Everychild Foundation, Jacqueline Castro. I believe we're going to see a short video.
Hello, and thank you for participating today. We are so glad that you're here. We're going to be talking about system-involved kids, and that's a loaded term. And whether it refers to those whose life circumstances have deposited them into the dependency system or whose lack of support and guidance have led them into clashes with the law, the term is synonymous with kids in crisis. And then when you take those who fall into both categories, you now have a subset who are probably facing the worst possible outcomes. A future of poverty, poor health, a lack of education, and probably even increased odds of being incarcerated as an adult. And all this has been predetermined by a rocky start in life that is no fault of their own. But it doesn't have to be this way, and that's what today's symposium is all about. Now, one part of the problem has been that the different sets of advocates for these youth historically have failed to work together, especially in matters involving education. Quite often, dependency and delinquency lawyers work in individual silos and sometimes even at cross purposes. So when the Everychild Foundation learned about Loyola's idea to develop a program to train lawyers to handle both aspects of this very vulnerable population, it really struck a chord with us. Everychild is a group of over 200 local women who each year annually pool funds, which we then turn into $1 million grant to fill a critical unmet need of children in the greater Los Angeles area. And ideally, we fund a project that is a new, innovative model that can be replicated so that we best leverage our dollars. And we believe that the Everychild Integrated Education and Legal Advocacy Project, it's a mouthful, is exactly that type of program. So in furtherance of this goal today, the symposium will be a chance for Sean Kennedy and his team to share with you this new holistic, integrated approach of crossover representation, especially vis-a-vis educational advocacy. And it's with the hope that this can lead to systemic change everywhere and produce improved outcomes for this particular group of youth. So thank you so much for attending, and most of all, thank you so much for caring about these kids who have so much potential. Thank you.
Okay. Thank you, Michael and Jackie, for opening the conference and framing the issues. We're going to dive right into our first panel. As Jackie said, there are two cultures, the dependency bar and the delinquency bar. And we both have mutual clients, but the key to helping those clients is to leave our different cultures or silos and work together to benefit our crossover client. And our next panel is going to flesh out all of the issues that come with that. And so I'm going to turn it over to Vivian Wong, who is an educational law attorney at CGLP, to moderate and lead this discussion. So Vivian.
Thank you so much, Sean. Hi, everyone. Good morning. Thank you so much for joining us on this session on effective collaboration when representing crossover youth. Again, my name is Vivian Wong. I am a staff attorney and adjunct professor at the Youth Justice Education Clinic within the Center for Juvenile Law and Policy at Loyola Law School. And I use she, her pronouns. And I'm excited to have our esteemed panelists introduce themselves. So please introduce yourself, your pronouns, and your organization and role. I'll hand it off back to you, Sean.
Hi, I've already introduced myself. I'm Sean, and I use he, him.
Megan, could you introduce yourself, please?
Good morning, everyone. My name is Megan Stanton-Trehan. I use she, her pronouns, and I'm the director of the Youth Justice Education Clinic at Loyola Law School in the Center for Juvenile Law and Policy. And our clinic, as you'll hear about, represents crossover youth in education proceedings, so special education, as well as making sure that they have all of their specialized rights that we'll talk more about. And we do some school discipline work as well. And of course, in the last year in particular, we've really delved into policy to make sure that the systems are serving these young people as they should. So that's just a brief bit about what we do. I'll turn it back over to Vivian.
Thank you. And now we'll hear from Jeanette Lomeli.
Hi, everyone. Good morning. My name is Jeanette Lomeli, and I'm a social worker at the Center for Juvenile Law and Policy with Loyola Law School. I use she, her pronouns. And to any fellow social workers who are tuned in, happy Social Work Month. And I'll pass it back to Vivian.
Yay, happy Social Worker Month. And we will have Isabel Daniels introduce herself.
Good morning, everyone. My name is Isabel Daniels, and I use she, her pronouns. I am a care unit attorney with the Children's Law Center of California, where I focus exclusively on working with dual status youth who are navigating both the dependency and the juvenile justice systems. I've been in that position for several years, and we've really enjoyed partnering with CJLP on some of our most challenging cases.
Great, and last but not least, Jaryn, please.
Good morning. My name is Jaryn Saritzky, and I use she, her pronouns. I am also an attorney at Children's Law Center with Isabel. And Children's Law Center represents all of dependent youth in Los Angeles County. I also specialize in focusing on representing youth who are involved simultaneously in the juvenile justice and dependency systems, and have worked closely with CJLP on several complex cases. So I'm looking forward to our discussion today.
Great, thank you all so much. So clearly we definitely have some experts on this panel from the various fields of dependency, delinquency, and education. And so I'd love for you all to discuss what are some of the best practices for cross-agency collaboration at all points of a case. What might that look like? And I can hand it off to Isabel to start us off.
I think one of the keys that we've learned is that across all phases of the proceedings, the earlier the collaboration, the better. Part of it is establishing a collaborative posture between the dependency and the juvenile justice teams, and making sure that we're sort of familiar with each other and creating a partnership between us that we can use to obviously assist the youth. I would also say that something that we found really helpful is, to the best that we can, establishing a roadmap that we can rely on sort of mutually. So on the dependency side, is our goal reunification? Is our goal relative placement? Sort of where are we heading there? And how can we work with our juvenile justice partners on facilitating that goal and posturing the juvenile justice case in support of that goal, and then vice versa. I don't know if Jaryn has additional thoughts about that.
Yeah, I'd love to jump in here. I think something that we've really seen is how both the dependency and juvenile justice cases are constantly changing and evolving. And I think that regular communication across all stages of the proceedings is really critical, because something that happens in the dependency court on Monday might have major impacts on what happens in the juvenile justice court on Tuesday. And so that ongoing communication and strategizing is really critical to the success of these cases. And I can think of one case in particular that I've recently worked with CJLP on, where it was really day to day, where the proceedings in both dependency and juvenile justice courts had major impacts on a family, where the allegations were surrounding a sibling victim and a sibling offender. And so what the dependency court's orders were really important to what the juvenile justice court's orders were, and vice versa.
Thank you. And Sean, Megan, Jeanette, anything to add?
I think collaboration is key. I agree with my friends at CLC. It's not easy. And so what I would say is, like, I came up a traditional criminal lawyer where nobody, you don't share anything with anybody else. It's all in-house. And I think many public defenders are super protective. But now I find myself sharing criminal discovery with the dependency team, and me asking them for a lot of the great life history information that they have that I could never get on my own easily anyway. And that can then be used to build social histories and mitigation narratives that are just excellent for resolving a case, plea bargaining or sentencing issues. And what I would say is this, that early regular communication creates a meaningful relationship between the representatives of the two systems. And I think the rule has to be, you share information, you're frank with each other, but in the end, the primary lawyer has to make the decision. So I always seek input from Isabel and Jaryn about my criminal strategy. And then I make the decision in criminal court and they make the decision in dependency court. And I don't always agree with their decisions. And I don't think they always agree with mine either. But I know what the decision is and I'm able to deal with it. And also I understand why the decision was made. And if I am pissed off about it, I can even call them up and we can politely argue about it. And it leads to way better strategic lawyering.
I want to just, can I hop onto that for just a second? I will say that one of the things that I really appreciate about our partnership is that level of questioning and inquiry. I think that it heightens all of our representation. I know that when we are in our, dependency mode and the caseloads are very high and sometimes things are normalized, that maybe we should question. I think that it's very effective to have a partner who is asking those questions and forcing us to think through them. So I think that also is really helpful to the cases and helpful to us as advocates just in our dependency zone.
And I'll take a minute to talk about our role as education lawyers and advocates as well on this team, because oftentimes in the beginning of a case, if we're just doing education advocacy, and we're not collaborating on a team like this, it looks very different, right? So we go in and we're, starting off at a certain point. It takes us much longer to work up a case. When we're working with our dependency and delinquency partners on a case, as Sean was mentioning, we've already got access to a lot of records, information. That helps us get kickstarted on a case much quicker, which can be really key for both, stabilizing placement in the dependency system potentially, as well as making sure that a young person can stay out of detention. So if we're able to get an education program in place quickly, that can be really key. And like I said before, I'd say if we weren't collaborating on a team like this, it would take us probably months longer, honestly. So that can be really, really effective, the sharing of records in the beginning. Also the case planning, because, we may have our mind made up about, our expertise in regards to what's best for the young person in education. But that may look really different depending on, what their placement is or what the goals are in terms of reunification or other things like that. So we all have to work together from the very beginning to come up with like a sort of strategy, right? I was actually just in an intake meeting yesterday with CLC care team attorney talking about the next steps for long-term planning for a case. And so those are all really, really important in the beginning of a case. I'll also say, as somebody who we really, in education advocacy, we go back and we look at the young person's records all the way back to kindergarten, even if they're in high school. This process of working together, we can easily identify reasons why the school district must assess the young person much, much quicker. And so that, and, also figuring out we even have evidence if the school district doesn't do a good job with their assessments. We often have evidence from delinquency and dependency reports of diagnosis and other information that we would never have had without that collaboration. So I think that's also something I'd really highlight about why this is so important across systems to serve the young people. And Jeanette, I want to hear from you.
Thank you. Yes, I agree with everything that's been said here about collaboration. One thing that I'd like to illustrate is I think, it's important to have a social worker on a team. I think it's really helpful in my situation to be part of the delinquency team because it covers, the client confidentiality extends to my work. And I think that's very unique, especially for these young people who have had contact with other social workers, but to be able to have confidential conversations with me is something that I found very unique and helpful in trying to build rapport. One thing that really sticks out to me in our work collaborating with everyone involved here in this panel it was actually my first client when I started working here at CJLP, and I'll call him Nathan. And I think many folks here recognize who that is. But Nathan was a young man who was already in the dependency system, and we started on his case when he was detained in juvenile hall. We had a court hearing for him and learned from the court that he was eligible to be released. But the problem was that we had no idea where his next step would be because he was in the foster care system and he had no parents, no family to go to. And so I stepped out of the courtroom. I was there. That's the other thing I'll just say really quick is that it's really helpful to have everyone involved present at the court hearings. And what I did there is I stepped out and I had already had contact with the DCFS social worker. That was a relationship that I think is important to try to establish with DCFS social workers and probation officers at the onset of the case. So I called her and explained the urgency that, this young person can be released from detention but has nowhere to go. And we knew that Nathan's younger brother was recently placed in a foster home and asked if they would be willing to take Nathan in as well. I ended up a call. A couple minutes later, she calls me back and says that they had accepted to take him in as well. So we were already in court. We were able to notify the court, provide them with the update, and he was released. And he had found stability, which was lacking in his life. So I think for me, that illustrates that as a social worker, it's important to collaborate with all of the stakeholders in the young person's life and to develop those relationships at the onset, because you really do want to explain your role and the purpose of collaborating here, not only amongst attorneys, but also caseworkers, other advocates, probation officers. So those are my thoughts on the collaboration piece.
And I just want to add too that Jeanette's role, as well as our other social workers who have worked on this case, and others in that role, has been so important because a lot of times as lawyers, we can't, or we aren't really allowed to speak with the social workers, or they're worried about that. But Jeanette, is able to do that, and folks are able to collaborate with her, and so that really breaks down barriers, I think, for our work and for the young people that we serve.
Thank you so much. So my next question, you've already touched upon it a little bit, but I'd love for you to elaborate. Through your work together in this project, what did you learn about the importance of effectively sharing perspectives in advance of any proceeding in each court to ensure that the best decision is being made from all perspectives and not just regarding any one attorney's specialty? What was the best way to do this? Jaryn, would you like to start?
Yeah, thank you. So I think, like we've referenced earlier, that ongoing collaboration and conversation between dependency folks and juvenile justice folks is really critical. And it's critical that it happens before each hearing. The ability to come up with a plan down to the details of defense attorney is going to make this argument and CLC attorney is going to make this argument. I think that can be really helpful. I also think that, a dependency attorney being able to explain the legal posture, the limitations or the abilities of the Department of Children and Family Services in juvenile justice court can be really helpful. as dependency attorneys, we're used to that arena, but we have to understand that our juvenile justice partners don't necessarily understand all of those nuances. And so having a dependency attorney who can explain that and perhaps even make some arguments or pitches or suggestions that the defense attorney might not be able to make because they don't understand the legal posture, or they might feel like it crosses a line. Maybe it compromises conversations that they've already had with the prosecutor, or compromises conversations they've already had with the bench. And then in terms of the defense attorneys, they have different obligations as defense attorneys, and different, they have different obligations. And so their arguments are rooted in the defense of their clients, and we can choose to have them focus on those arguments as opposed to the arguments related to a youth's dependency status. So I think it's just really critical to have ongoing conversations and planning about who is going to take what approach at each hearing. And that also might mean that a dependency attorney doesn't appear at a particular juvenile justice hearing because there isn't something beneficial that that attorney can add to the conversation.
Isabel, would you like to add anything?
I was just thinking about this in the context of like specific bridges that you might cross. So I think one of the inflection points that we encounter a lot is changing the lead between DCFS and probation. And I think we've all learned that lead changes need to be approached with a lot of care. And so a lot of coordinated planning needs to happen before that's proposed. And so, I think a lot of conversations about case strategy and case plan can help lead us to the point of executing lead changes effectively. And again, it's that ongoing collaboration piece that makes it possible that we can all bring in on both sides. But, if the juvenile justice judge is the one making the lead change, then we make the case in that court.
If I can just piggyback off something Isabel just raised, the idea of lead change also might require a dependency attorney going into dependency court and seeking certain orders before we come to juvenile justice court. For example, we want DCFS to assess a particular relative for placement so we can report to the juvenile justice court what DCFS thinks about this particular relative. Or we want DCFS to initiate a short-term residential treatment program screening. So there are things that might happen along the way in between juvenile justice hearings. And that's why that ongoing discussion is so key.
And then I also, just to also relate to something that Jeanette was talking about, which is following up with the social workers. So for example, say we've gotten an order from dependency court that DCFS is supposed to be assessing a relative, then that repeated follow-up with the CSW and our ongoing communication about that process can really help all of us to make sure that our plans are on track to move forward. And that if they're not, we on the dependency side can take steps to talk to county council, talk to the social worker, talk to the court, whatever needs to happen to ensure that those plans are actualized.
Something that comes to mind is also, there was a case, for example, where I think the court was recommending that they close a DCFS case, and this specific family that was involved, I think that they were ready to, in terms of their reunification, they were ready to close a dependency case for those reasons. But at the same time, what the court wasn't aware of is that DCFS was also trying to support mom in finding housing. And we knew that if they closed the DCFS case, that would mean that mom wouldn't have access to those resources that were really critical at the time to help create stability for both the young person and the parent. And again, this was a situation where we were all in court, and right before they were going to make the decision, we were able to chime in and just say, hold on a sec, I don't think this is the best idea for these reasons. So, by communicating this with the dependency attorneys, we were able to ask the court to make sure that that DCFS stays active in supporting mom to find housing.
Yeah, and I want to talk about that case for a minute too, because there were so many valuable experiences that we've had in terms of our, working together in the moment as well as before the hearing because of our ability to work together in court. Of course, that has been more challenging as we're appearing in court all virtually, and I can't wait for us to all be back in person all the time. But I just, I think there's nothing like being able to, address issues as they come up all together as a team. I know Jeanette and I both really, relish the opportunity to participate in those kind of collaborative efforts in the crossover court that was serving both, dependency and delinquency issues. And we're able to come in and say, this is what's happening on the education side. And in that particular case, for example, the young man was struggling in school because of things that were happening where he was living, which was, somewhere that, while on paper looked okay, was a challenge. And so we were trying to support the family by saying, look, we really need to make sure DCFS stays on this case. If you don't, he's probably, something's going to happen with school or something's going to happen elsewhere that he may actually have to be, removed eventually. And so being able to be there and really share some of that, and, also Jeanette's ability to build rapport with the family and sort of gather that information in a way that was, confidential, was helpful. To help problem solve in that case. So of course, before we get to the proceedings, but also at them is really a time where we could, really collaborate together.
I think working inside your own court only and saying, well, this is the universe I'm in is not effective in these cases, because there are two systems going on in parallel, and the idea is that it's double support. The delinquency system is moving along, and you have probation kind of in charge, and then the dependency case moves along. It seems like to me more slowly, more long term. And you have the DCFS, and so it's like there's double resources, double support in theory, but in reality, each side plays against the other, and probation says that's not our responsibility, that's DCFS's responsibility. And DCFS says, well, why are you looking to us? He's in the criminal justice system, he's in the juvenile justice system. That's probation's responsibility. And one of the advantages of working with the CLC lawyers on this panel for me has been that it has helped me cut through that narrative of obfuscating or evading responsibility for a young person, particularly as they transition out of the juvenile justice system, out of detention, into the world. Because as criminal lawyers, you have a big victory in court and it's exciting, but what good is it when the kid is going to be released, but he's set up for failure? And so many of my clients are, because there hasn't been the appropriate planning to get them in a housing situation where they can succeed. And then they end up in a shelter, and then they AWOL, and then you're back to square one. And so collaboration with the dependency team, I think, really cuts down on each side passing the buck to the other side to the disadvantage of our mutual client.
I think Sean just hit on a great point. The problem is that the two systems that are supposed to be serving these young people are not communicating with one another well. And that's why Isabel's and my positions exist, to help fill that gap. And so to the best of our ability, when the advocates can communicate and share information and strategize together, the hope is that we fill that gap. And it's unfortunate that it's up to the advocates. In a perfect world, the social worker would be communicating regularly with the probation officer and planning for this young person's future. But unfortunately, that's just not how it happens. And so it's really up to the advocates to be communicating. And once in a while it happens and it goes great and it's wonderful. But I think that that doesn't happen as frequently as we would like to see.
Yes, that is very frustrating. So Megan, you mentioned crossover court earlier. How have we been able to improve the 241.1 process through cross-agency collaboration for our clients? What kind of practices would further improve its effectiveness? Anybody itching to start?
I have strong feelings on this.
Take it away, Sean.
Megan, do you want to start? Or, I mean, the MDT 241.1 report. So supposedly, right, in this crossover environment, we're all working together to help crossover youth, foster kids in the criminal justice system. So the MDT team, I think it's the multidisciplinary team, meet, and they're supposed to bring to the table all of their special education and training. So you have school psychologists, the probation officer, the social worker, and sometimes there'll be mental health expert advice. And they're supposed to come up with a plan that crosses over both systems, that is comprehensive, that talks about who's the lead and what should be done with a young person. And in fact, it doesn't seem that way at all to me as a criminal lawyer. Usually it's someone detained. A lot of times they've committed serious offenses, and yet the criminal lawyer isn't invited. The juvenile justice lawyer is not even invited. Fortunately, CLC is, and so the dependency team can clue me in that it's coming up. They can try to get me an invitation, and we can work together to present a compelling mitigation narrative that will be ignored, in my opinion, if the two teams don't collaborate and go in with that plan. Because even though you have all those professionals, it seems like all they do is defer to probation, which has a very negative narrative about gang membership, young people who commit crimes. It's pretty cynical. And by tag teaming the MDT team, you can actually really have success in a way I never believed, because at their heart, they're trained, they're social workers, they're psychologists. They understand the root causes of delinquent behavior, but they're not going to extend themselves. And so if probation runs the show, you're going to get a really bad MDT. But if the juvenile justice team is brought in by the dependency team, and we all work together to tag team that MDT, I think you can have real success. And we have had real success, even in like gang shooting cases, by going in together.
I think the idea of this 241.1 MDT, and for folks who aren't familiar, this MDT is it creates a joint recommendation from probation and DCFS as to which agency is going to place the youth, where that youth will be placed, and then what services or probation conditions should be part of that youth's case plan. And the recommendation isn't binding to the court, but I think Isabel and I estimate it's followed about 60 to 70% of the time. And so meaningful participation in that MDT can result in a favorable recommendation. And that's just one other hump you don't need to get over in order to convince the court of your plan for this young person. I think that, as Sean mentioned, strategizing before the MDT and coming up with a plan as to what your pitch is really critical. Even if both defense and dependency can't participate in the MDT, having at least a discussion about what are we trying to achieve here? Are we trying to get a particular DCFS placement or placement with a particular relative? I think one problem with the MDTs is they're often scheduled at 10 or 11 a.m., which is when most attorneys are in court. And so just one concrete, meaningful difference could be, let's set all of these MDTs for the court lunch break so that all attorneys have a better opportunity to participate. And I'll pass it over to Isabel to see if she has any.
Yeah, I just wanted to add on to that, the impact that having a strengths-based advocate in that space can have. I know that we are our care teams, we attend every single MDT, and we've seen over and over again the impact that having somebody there who can say, here is what this young person is good at. Here is this young person's interests. Here are the ways in which this young person who has these interests or who has these strengths is not being nurtured, but could be if we do X, Y, Z, instead of taking the tone that we're currently taking, which is bad kid, incorrigible, sort of all of the stereotypical things that get said about these clients. And I think it heightens it even more when we can get meaningful participation from our defense colleagues in crafting that strategy and what we want to bring. It is a collaborative space, so we've noticed that sort of the approach in that environment has to be much more, we're partnering with you, we're not fighting with you. But when we come with that attitude, I do think that there's meaningful engagement. And Sean's laughing because he knows that sometimes we have to temper ourselves when we come into those spaces. But I just think it can make a tremendous difference, and does in many cases.
Yeah, and I'll just jump in too on the education side. I think what was discussed before about one of the challenges of these meetings is that it doesn't always include people that are working directly with a young person because of the scheduling challenges and other issues. And so it's often just another sort of bureaucratic administrative process. And it doesn't have, it's not as meaningful for the young person or for those of us who are executing the plan moving forward, right? Because we're not necessarily there to help craft that recommendation to court, and that then results in decision-making in that process. And I think from my perspective as an education lawyer, I'm often frustrated because the records are often outdated that are used in those meetings. They may not even be fully understood. So for example, we had one case that I'm thinking of that we all worked on where I knew I really wanted to be in that MDT meeting or at least provide input. So we made sure, Sean asked the judge to make sure that it was included in the judge's orders that the MDT team consulted with us, because we had the most updated information and could explain the IEP, individualized education program, and what was needed moving forward for this young person, which was really important because we had just received really new assessments that, in the school setting documented the trauma of this young person and actually recommended a residential treatment center, which the previous records did not recommend. And actually, when we heard what was being talked about or what was in the draft MDT report, none of that was there. So without Sean thinking, let's make sure we have our education team give input, none of that updated information with that context would have been available to the MDT team. And that was really crucial in figuring out what was going to happen next for that young person. Because then we knew, this offer of an RTC would be there in this education setting when the young person was done with the placement that he was going to be in next. So that's just one example of something. that, is really key on the education side as well, because those records, it's very specialized, right? That's what I do all day. Not everybody is going to pick it up and be like, oh, I understand exactly what this says. So it's really important to make sure that, that's going on in those meetings.
I also want to say that, I think that working closely together, especially for these MDT meetings and reports, can pay off because like the criminal lawyer is going to know what happened more deeply than the probation officer or anyone else in the MDT room. So my experience is they really focus on the criminal discovery prepared by the cops as if that's holy writ when they talk about what the client did and who he is and whether he's violent. And they also adopt a really police gang expert narrative about why young teens join gangs. And so, like, I can think of a case where it was a gang shooting, but there was a lot of evidence that it was a BB gun, not a real gun. And that was able to change, I think, some of the tenor of the evaluation during the MDT, but they wouldn't have known that if CLC hadn't brought me into the conversation, because it was all on body worn camera. It wasn't in the original discovery where the victim said it was a BB gun. And I also have seen, like, the team places so much importance on certain crimes, violent crimes. But if you're out there plea bargaining with the prosecutor, let's say you're litigating a bunch of motions, you're doing a social history, and it's all towards getting a good plea bargain and you get it, sometimes you can use that plea bargain to ask for a revised MDT, since it's a completely different offense now. And since the people doing the MDTs place so much emphasis on the offense, if that shooting is gone, your options could open up. And talking with the dependency team, who knows that world way better than I do. And I was laughing at Isabel because it feels so weird, because I will go in there wanting to fight like you do in criminal court. And it's like, you have to be politely told, hey, stand back, mellow out a little. And so I just think that the area of MDT 241.1 is one of the most important areas for true, real, regular collaboration between the two sides.
And I'll just chime in just to provide a little bit of background from the perspective of a social worker. I think part of my role, for example, includes conducting an adolescent assessment, which is an assessment that gathers information about the young person related to their biological, medical, social, family, school history, trauma history, and we use this information to put together sometimes a social history or just put it in writing and share that with the rest of the legal team so that we have more context holistically about this young person's life, and we can use that information in these spaces like these MDT meetings to, as Sean was saying, to give them the complete narrative and challenge what we usually hear in those meetings.
And I'll just quickly answer. I see there's a couple questions in the chat about are school social workers ever involved in the MDT? So typically nobody from the school is really involved in these meetings. It's, folks involved in the court systems and those that supervise. So even if the young person has a court-appointed education lawyer, that person's not even necessarily included. It's usually somebody in the DCFS or probation that has the education records or has some education records and kind of prepares that part of the report. But certainly I think, the more that you can get, somebody that knows the young person and also is an expert in education involved is beneficial, whether that's a lawyer like me or somebody that works with them in their school.
Thank you so much for your insights on the 241.1 process. So what are some practical strategies and tools for improved information sharing, trust building, and effective collaboration? Really trying to get tangible here.
I'm happy to contribute one thing that we do that I think really helps, at least me, which is to have what we call case staffings, where we invite all of the players to the table, all of the attorney teams to discuss the case. And that includes defense counsel, that includes education team, that includes care team from CLC, dependency attorney, sort of everybody who's involved in the legal representation of this youth, to talk about, you know, where we've been in the case, where we are, and where we're trying to go. And I think that that serves two purposes. One, it helps establish our team dynamic as a collaborative team, which I think can be really helpful to just have people looking at each other and engaging and getting a sense for each other and building a partnership that way. And then obviously also so that we can all get on the same page with the youth, coordinate our case plans, coordinate our case strategies, make sure the youth isn't being over-serviced. So I really like using those case staffings for that purpose.
I'm sorry, how often and how frequent are those?
So far in on my team, we use them sort of as needed. And we do have a goal of starting to do them at the outset of a case on every case. We haven't achieved that goal yet, but that is my ultimate goal. And then sort of after that, do it on an as needed basis. Obviously, that's an evolving process and folks are very busy, so it can be hard to coordinate, but that is my dream.
I think a couple of other concrete things that can happen are the sharing of reports, especially dependency records. You know, sometimes these young people have been involved with the dependency system for so long, and they have had so many placements and so many different mental health diagnoses and so many school placements. And so sharing those reports, I think, can be really helpful. For example, for the creation of that social history that Jeanette is referencing. And then also dependency attorneys, CLC players, and even case managers or investigators who support clients can write advocacy letters to go to the juvenile justice court or go to the 241.1 MDT team. And a lot of times those letters can be really powerful in not only talking about a young person's history and diagnoses and special education needs, et cetera, but also talk about what the options are. What are the options in the dependency court? What are the options through DCFS placement? And even citing particular welfare and institutions codes that gently remind the bench officers that there are certain things that they can't do simply because someone is in foster care. You know, they can't hold them in custody simply because they're in foster care. They can't charge them restitution fines if they're in foster care. So there are legal advocacy strategies that we can utilize in those advocacy letters that I think can be really powerful.
I think on that note, one thing that I find, and I keep referencing this, but one thing that I find very powerful is when advocates across, different areas come together to the court hearings to advocate for the young person in person, not virtually. But I think, one example that I can think of is we had a client who was also a regional center consumer, and we were also able to get in contact with those folks, and they were able to come out to the court hearing. And this young person had no family, but they had a courtroom full of advocates from different areas who could vouch for the young person, and again, just paint a different narrative, a fuller narrative of their strengths. So I think for me, one of the more tactical strategies is if we can bring stakeholders and advocates from different areas of the young person's life and have them join us in person. It's really great to have that courtroom packed with advocates for the young person, especially when they don't have family.
I definitely agree with Jeanette on that front. I think that makes a huge difference. And something else I would say that we have instituted in our, since this project began, in the education side of things is making sure that we provide court update letters on what's happening on the education front, because oftentimes, like I said before, the records that the court may have, even from probation or even from DCFS, they may be outdated. Also, it doesn't provide a fuller picture of like the legal requirements that the school has, and whether or not there's been any legal violations, for example. So oftentimes there might be, delayed special education assessments, or services haven't been provided, or sometimes, our clients experience discrimination where they're not enrolled in school right away, despite their legal rights to be enrolled. And so if you just look at it from the outside and you think, oh, well, this person's not enrolled in school, why are you not enrolled after a month or something, without the context of, well, we've been fighting to get them enrolled, this is what's happening. Without all of that provided, it's really, difficult for, I think, the courts to understand what's going on in that other system. And of course, I say this to my students all the time. A lot of times understanding the school system that exists now, and for these young people, it's a very different system than, to be honest, a lot of the judicial officers probably understand or know. So it's a really important education piece, to make sure that they're seeing what our clients are going through in that school system, and their challenges, as well as, some of their strengths. So, making sure if they are getting an A or a B in certain classes, that we really put that up front, rather than focusing on maybe the last report card where they had some poorer grades. Just really making sure to use that as an opportunity to lift up the strengths of the young person as well as their family.
The collaboration, it's got to be real. So, like just emails announcing something that's a fait accompli is not that great. I mean, it's better than nothing. I'm sure Isabel and Jaryn would love it if I would be more on top of telling them when the next delinquency court appearance is via email. But the kind of trust that you're talking about, Vivian, I think comes from things like saying, I'm going to file this motion, or I'm going to file this sentencing position paper or disposition, with mitigation. Do you have any comments? And when they give you comments, it's great, because often CLC will offer me like exhibits that support something. And also, like, when I say not a fait accompli, like, okay, so in your system, this is all figured out, and you think that this is a loser. An example is kids who turn 18 in Dorothy Kirby, right? That's a loser. They're not going to get extended benefits. But, we took all that input, we researched it, and we decided, no, we're going to file this motion in delinquency court, and it won. And so, like, that real, I think, engagement with each other creates a higher level of representation on both sides. And it's also just a lot more fun and meaningful litigation when you're doing it that way. So I think that's what it is. Give yourself time to really collaborate. Don't announce 5 minutes before you step into court to your partners on the other side what you're doing, and make it clear that input is not wanted.
I think Sean referenced this earlier in our conversation. Defense attorneys and CLC attorneys, dependency attorneys, have different legal and ethical obligations to their clients, and it is perfectly okay for the two sides to disagree. I don't think it happens very frequently. I don't think it's super common, but on occasion it might happen. And I think that that's okay. I think we need to recognize that we have different obligations as different teams. And as long as there's communication about what impact those obligations have and what an attorney can represent in court, as long as there's an understanding about that. That's just part of this process, and we can use those strategically at certain hearings and at certain phases of the case. But I think that's just something we need to be aware of and comfortable with, that sometimes we might disagree, and that doesn't mean that we're not collaborating, or it doesn't mean that we're not advocating on behalf of our clients.
Thank you. And so we touched on this a little bit, but if you could speak to what are some key barriers to effective collaboration, and what are some of the strategies for overcoming them?
Go ahead, Jeanette. Go ahead.
I was just going to say, thank you, Isabel, that one thing that comes to mind for me is, we've talked a lot about having advocates and support systems for young people, but sometimes the reverse can happen where maybe we have young people who are overserviced. And I can think of an example where we had a client who was placed in a group home, so he had support staff there. He was transitioning out of the group home, and from there had the aftercare unit continue to support him, while at the same time he was working with me with the support of CLC, support of other community-based organizations, and it became, we put together a lot of support services, because I think he had a lot of risk factors, but really I think it can kind of overturn where we began to see him feeling overwhelmed, feeling stressed, not really accessing these services. And I think that can happen, right? I think we need to acknowledge that can happen, and it's always important to reference and go back and speak to the client to ask them, like, hey, how are you feeling? It's one thing for us to make all of these recommendations and link them to support services, but sometimes they might not really need them, even though we are the professionals and the experts. They really are the experts in their life and what they think is important for them. So I think that is a challenge and a barrier for me sometimes, and in my role is really acknowledging how all of these things can play and affect them. So I think it's important to keep that in mind as we start to try to empower these young people and ask them, like, hey, how are you feeling, right? Like, bring them to the center of the conversation. And for this specific case, we learned that he was very vocal, and he was a great advocate. So we learned from him directly that he felt overwhelmed by all of the service providers, and was able to identify a couple key supports, but other than that, he said that he was okay. And we listened to him and did that, and sure enough, he's been doing really well. I think there's always a concern that maybe he doesn't have enough support, but I think, again, just reverting back to reminding ourselves that these young people and children are really the experts, and many times they've had multiple service providers, different therapists, different social workers. So they, really, it's important to reference back to them and ask them how they feel about everything that's going on around them.
Sean, do you have any thoughts on barriers to effective collaboration?
Yeah, I think that it's hardest to collaborate if one side is going to be judged or graded by the other. So, like, there are times where I've negotiated a plea agreement, and counsel on dependency side want me to do something. I'm like, I can't do that because I'm going to violate the plea agreement. Now, I think their answer is that, right? Because they can do it for you. And then other times, I'll be righteous with CLC about not coming down on DCFS, and it's really frustrating to me. And after talking about it, I realized, that's complicated. You might need to defer to your colleagues on the dependency side, because we're not winning anything if you have a victory in delinquency court, but there's no feasible, workable plan for the kid as he leaves custody. So I think just working hard not to grade or judge your counsel on the other side makes collaboration work a lot better.
I think one barrier to success is how often we encounter foster youth experiencing long stays in juvenile hall because we don't have an identified placement for them. And again, the law doesn't allow that because DCFS has transitional shelter cares. But we also know that those transitional shelter cares have limitations, and bench officers are sometimes not inclined to release, certain young people to those transitional shelter cares, especially when they have high needs in terms of their mental health, maybe regional center consumer status. And so it can be frustrating when these young people have to experience incarceration for long periods of time while the teams figure out what the plan is. So that's definitely a barrier. And some bench officers are more willing to consider plans before resolution of the case than others. So sometimes it's just kind of strike of luck in terms of what bench officer the case is before.
I would also say that in a lot of instances, these cases, these dual status cases are very, very labor intensive and take a lot of resources. And a lot of our dependency colleagues have extremely high caseloads, and it can be very challenging to, do your regular caseload in addition to really having the time to put in to effectively collaborate and do all of the follow-up that is required on these cases. And one way that CLC has tried to mitigate that is by expanding the care units that Jaryn and I are a part of, so that we can kind of liaise with our defense colleagues and be present in juvenile justice court and sort of, shepherd that process and provide additional representation. And it is also a goal of CLC to consistently reduce attorney caseloads, but it is an ongoing problem. Not every client at CLC who comes into contact with the juvenile justice system is a care client. And so that is a challenge that we are constantly trying to figure out how to overcome.
I also see a question about trauma and how these young people who are dually involved in both systems have often encountered lots and lots of trauma throughout their lives. And as many of us know, trauma has lasting impacts on a youth's brain, how a youth responds to high stress situations. And so it's something that, as advocates, we are always trying to keep in mind, and we're always trying to encourage trauma-informed responses, but I don't think the systems do a good job of it. And so I think it's our job as advocates to constantly be reminding service providers and courts about the trauma that these young people have encountered and endured and the impacts that has. I also think that as professionals and advocates, we need to remember that working with this population can be traumatic for us. And, sometimes when you see a client experience trauma after trauma or unsuccessful placement after unsuccessful placement, I can speak for myself. I can feel hopeless and I can feel demoralized and frustrated that we've put all this work in and it wasn't successful. And so I think that's just something to keep in mind and to continue to vocalize to our colleagues, because our colleagues understand it and are experiencing it. And even if there isn't a clear solution, just talking about it can be really helpful and meaningful. And I also think it just continues to remind one another that, both our clients and our advocates need to be focused on healing trauma and addressing trauma. And I see that there's a whole panel on trauma tomorrow, so that's wonderful.
I'll just quickly touch on one of the challenges or barriers that we experience as education lawyers or advocates is just I talked about how long sometimes our cases take, the timeline's not matching up with what's happening in either dependency or delinquency. The schools have their own timelines based on the laws that govern them. And so trying to, do our best to communicate what that is, but also doing our best to try to plan around that. Things take a long time in our system sometimes. And even if you get, a plan in place for the young person, a new special education plan with new services, that doesn't mean it's going to work tomorrow. A lot of this is going to take time, especially for youth who have been in 10 different schools, who have, a lack of trust for service providers or various other issues, so that's a barrier that we face and a frustration, because, we can get something and say, this is our plan, but, unfortunately, without that collaboration, which we do have, but, also without the understanding and explanation of what's happening for the young person and really focusing on that trauma side of things, it's hard for sometimes for folks that are overseeing them, and either the judges or probation, to really understand this is not going to be, they're not going to just get straight A's right away when you give them an IEP. It's going to take time. So that's another barrier that I think through working together and joint messaging and advocacy, we can overcome.
Great, thank you so much for all of your insight. At this time, we have time for questions from the attendees. And I see a question about what is the role of educators and college professors in this whole process?
Sean, do you want me to start answering that? Okay. So I think, just a little bit of background. I was mentioned in the introductory remarks, but both the Youth Justice Education Clinic and the Juvenile Justice Clinic here at Loyola, we are teaching clinics, so we represent our clients, and we've been speaking today in this panel about the direct representation that we do, but we also teach law students how to work with this population of clients, and how to do the legal work that's involved in whatever clinic they're in. So we're technically, sort of professors in that way, by helping our law students learn how to work with these students in a trauma-informed way, as well as how to zealously advocate for them in whatever forum they're in. I think in terms of educators, our clinic, the Youth Justice Education Clinic, we really have a collaborative approach to dealing with schools as much as possible. That is what we like to do. We attend school meetings and we work with the school teams. We are not solely adversarial because we believe that working with schools and educators is ultimately the best for our clients in the long run. And we only really move towards more adversarial proceedings if we're not getting what we want through the collaborative process. But we definitely see our education partners as partners in this work, which is really what the law intends under the IDEA for that. So, Sean, do you want to answer some more?
I hope I'm answering the right question. I was a career public defender before I taught. I did that for 23 years. And, I learned all the old criminal lawyer tropes. I'm a lawyer, not a social worker. Public defenders are not allowed to do holistic stuff because we're there to battle it out in court. I'm not, and I, as a teacher, I try to teach young juvenile advocate, juvenile justice advocates or public defenders or dependency lawyers that come out of our clinical programs to not make all the mistakes that I made as a young public defender because of those wrong-headed lessons that were conveyed to me in the late 80s and early 90s when I was a rookie. I think we have to be social workers for a client. It doesn't come naturally to me, which is why I appreciate having someone like Jeanette on a team. I'm much more interested in the legal battles, but the clients have so many needs that have nothing to do with court. I think it's just essential. And so I think that the way we train young legal advocates to represent clients is so important to reforming the system and really putting in an emphasis, just like people were talking about trauma, holistic services. What happens after the courtroom battle? You can't close yourself off from that. And I think that in legal teaching, the biggest thing that we can do is train young lawyers to be more client-centered, more holistic, more trauma-informed, because that's the only way they're really going to solve their clients' real problems.
Thank you, Sean. And then our last question will be, how has COVID-19 impacted your collaboration? See some smiles and nods. Jaryn, take it away.
I think it's impacted it in massive ways. I mean, both in terms of the availability of supports and services for our clients is less. And it's really frustrating as an advocate when even pre-COVID, there were things that were available to our clients that aren't available right now. I'll give a concrete example, something called wraparound services, which is, where a clinical team wraps around a young person and their caregiver. And there's, a child and family specialist and a facilitator and a parent partner. Most of the agencies providing wraparound services are only doing virtual sessions and meetings right now. And that's just not as effective or meaningful in most cases as in-person services. So both on the services side and then also on the advocacy side, I know that there are certain times when I don't feel as effective as an advocate over Zoom or WebEx. And I know that, Jeanette highlighted the importance of being together physically at these proceedings, both so that the young person feels supported, but also so that the court sees, everyone on this young person's team. Physical presence makes a real difference. And so I think it's impacted it in a lot of ways. On the flip side, I know that Isabel and I are able to be in a lot more courtrooms on a given morning because we just switch from one WebEx room to another. So there are some benefits to being able to attend these hearings virtually and being able to set up meetings without having to drive to various locations. But I think at the end of the day, we need to remember what kinds of supports and services and access to justice our clients are getting. And that needs to be our focus and not convenience.
I'll just add to that. Something that I've noticed is that, for example, we might have a young person who needs to complete terms of probation, which usually include completing community service hours or certain substance abuse classes. And a challenge that I've seen because of the pandemic is that there is very limited resources for that, especially at the very beginning of the pandemic. How can we have a young person complete community service hours? So because of that, it's sort of hanging over their head, and it's been difficult because of the pandemic. But things have been changing, so we're hopeful that more support services will come up, and we can really hit the ground running with all of those.
I also think one of the challenges is, before the pandemic, oftentimes when we would interact with our clients, we would be doing so in a very coordinated way where, we might meet with the client with our defense colleague right next to us, and the client, we're all explaining together sort of who the players are and what role we each play. And I think that I'm seeing a lot of clients experience confusion, especially when they have really robust teams, which is kind of like when CARE and CJLP combine, it is a very robust team. I think that sometimes the clients become confused about who everyone is and what everyone's doing, and not being able to have sort of that in-person interaction is very frustrating for me and for them as a result.
I would definitely agree with Isabel. I think even, as Sean and I were saying, we have law students that work on our cases as well. For many of them, during this year of COVID-19, it's been really challenging to make those connections with the clients that they normally would be able to. Some of them are just so excited now that they're starting to get that. One of my clients yesterday invited me and the law student to her graduation that's coming up. It was just so sweet, but I haven't seen her in a year in person. And it's just, Jeanette and I used to go and visit her regularly, at her home, and I used to go to her school all the time. And so those kind of challenges that everyone's experiencing are uniquely difficult for our clients and for maintaining that connection, especially when, you're dealing with a person that is a young person that has all these different system players, like, who are you again that's calling me, right? And probably a lot of fatigue for answering the phone to all these people that are calling. And especially when school is online and counseling services may be done over the phone, they don't necessarily want to talk to us in the same way as, when we could go visit and be like, hey, let's chat real quick. And, we get to celebrate their birthday in person, things like that. It's not the same. We do our best, but I think that's a huge challenge of COVID. I could talk a lot about the school related challenges that our clients have faced with technology and other issues that, we'll talk more about in panels later on in this conference. But communication of all of those issues and helping folks understand them is another challenge of COVID, because as we know, there's a very big disparity depending on your wealth, your background, of how you're experiencing this pandemic. And a lot of our crossover youth clients are experiencing the worst of it in every possible way, right? And so making sure that, they're not in education pods, right? They're not in that kind of experience. They have issues logging onto their virtual classes. There's too many kids in a group home that, mess up the Wi-Fi. So anyway.
Sean, do you have any thoughts?
I think COVID-19 has really increased the already strong pressure in juvenile court to engage in kind of a assembly line justice mentality. I really worry. My clients are never even invited to come to court, and when they do come to court, they can't hear anything. You can't communicate with them, and really, I feel like the court sends a message that they don't want any of us there. And I think the only way to deal with that is written motions and written presentations become all the more important. If you file a memorandum beforehand, at least the judge knows, hey, this is different, and knows more than the information that is conveyed in a WebEx hearing, which I think is very little. I often miss half the hearing in a WebEx hearing. So I wonder what my client catches.
Thank you. So we have a minute left. Does anyone have any concluding thoughts they'd like to share? I know we have a question in the chat about educating the general public who feel that youth should be held accountable for their actions. If anyone would like to respond to that.
I think that educating the general public is an ongoing process. I think that things that have happened in recent months and years have helped move that process along a little bit. I think, for example, the election of our current district attorney, I think reflects that there is a recognition by the general public that we need to be looking at these kids a little bit differently, and we need to be looking at them holistically. So I think our just continued advocacy efforts are really what it comes down to. And I think, just as a closing thought, I'm just so grateful to CJLP and to defense colleagues who are willing to collaborate with CLC and with our teams, because I really do think it can make a meaningful difference. And as hard as the road feels sometimes, I really do think that often it results in better results for these young people.
There's a lot of holding to account or accountability to go around in the system. It's not limited to our young clients who are struggling with incredible problems out there on the streets before they ever meet us. And so, that's what I think. But the model that we advocate for in this program of really hashing it out and communicating with each other and planning out strategy together, I think is the best way to hold ourselves more accountable and representing foster youth in the juvenile justice system. And so I like you, CLC lawyers, I appreciate the opportunity to work with you, because it's really upped our game in juvenile court.
Thank you so much, and a great note to end on, note of appreciation to everyone. Now we've concluded our first session, and we'll take a 10-minute break and be back at 10:40. Thank you, everyone.
Thanks, everyone.